of Institution Innovation Council. So according to the IIC calendar, today is World Intellectual Property Right Day. So this day is celebrated because WIPO is a organization, World Intellectual Property Organization WIPO. Since 2000, every 26 April, they are celebrating World Intellectual Property Right Day to promote the intellectual property across the globe. So today we are having our eminent speaker, Dr. Aditi, Professor in Department of Pharmaceutical Chemistry. She is heading the IPR activity coordinator position in IIC of Laureate Institute of Pharmacy, and previously she has also experience in working in lovely Professor University in IPR department. So I invite Professor Dr. Aditi Kaushik Madam. The stage is yours.
गुड मॉर्निंग सर। एक फोटो यहाँ से खींचिए ना, यहाँ से पूरी सबकी।
About the intellectual property rights, right? Today, with this, I would like to start my presentation on that is empowering innovation through IPR. That is the heading of my presentation. Is it visible, students here? Lights are visible. So first of all, the title is empowering innovation through IPR. So it has basically the three words, that empowering innovation and IPR. These all the things are interrelated, right? So first is innovation. So I would like to start with the word innovation. Innovation is what? Innovation, first of all, we should know about what is innovation, why innovation is needed, and how that innovation can be achieved. These are the three important points regarding that innovation. So my first slide indicates about innovation and what is innovation. Innovation means, as Hindi term, innovation means it's a novel or naya. Yeah. So that is a new product. It may be new process. It may be new machinery. It may be new product or service or solution. So innovation means the process of bringing about any new idea, any new machine, any new process to the market. That is known as the what is innovation. And next step is why innovation is needed. It is needed to better therapeutics is needed to meet the requirement of the users, to meet the requirement of the society, so that the society can be benefited. Clear? So that is why innovation is needed. Like in case of the chemistry students, they have studied the SAR of the activities. SAR, why they have studied the SAR? Because the serious drug is not up to the mark. It will causes the diseases, or it will causes the side effects to the patient. That's why they are needed the new drug. Like our M.Com students undergo the various types of research. Why they are doing the research? To meet the new product, or to meet the user's requirement. Now, how the innovation can be achieved? Now, कैसे आप innovation achieve कर सकते हो? That can be achieved by the thorough experimentation. Clear है? ऐसे नहीं होगा कि आप लोग just you will have an idea or start processing. No, you should have the proper use of the thoughts and use of the proper experimentation or proper research processes that are important in carrying out the innovation. So next is this slide indicates the steps of the innovation. Innovation में कौन-कौन से steps involved होते हैं? So first is identifying the problem. First of all, you should know about why there should be the need of innovation. क्यों हमें problem का पता होना चाहिए. Second is generation of the idea relating to that innovation. Third one is developing a prototype. You have to develop one synopsis, or you have to develop one sort of a instrument, which is the basic instrument, which is just on your lab basis, which is to be further modified to the industry. Then fourth one is this testing and alteration. Testing means you suppose you have anyone has developed this pen, whether it is working properly or not, that will be testing, and further alteration will be done. Then last is the implementation of the product. That means when there is a final product, it should be implemented. That should be transferred to the industry for the further scale up, right, for the production. So these are the steps of innovation. Now, why I give you brief about the innovation? Because innovation can be easily achieved by the use of the IPR. It has a important connection with that of the IPR. IPR is what? That is intellectual property right. It will support the innovation. How it will support the innovation? कैसे IPR जो है इस word है छोटा सा, लेकिन वो कैसे support करता है innovation को? कैसे करता है? By incentivizing the innovation means by providing the financial support. It will give the financial benefit to the individual. Suppose any student will formulate one new formulation, or any student will say कि it will also will say just design a new pen. So this pen is the property of that particular student only. अगर किसी को उसको use करना है और sell करना है, he or she should have give the money. तभी वो उसको sell कर पाएंगे. Clear? So that is incentivizing innovation means it will provide the finance. And it will further protect the innovation and promote the research and promote the technology transfer. So these are the how that IPR support the innovation, or how the IPR will empower your innovation. Now I will start with my third term, that is known as the IPR. Empowering innovation to IPR and to the title. So I will start with that third term, that is intellectual property right. Nowadays, that is very important. Intellectual property right, first of all, we should know about these two terms. What is intellectual property first? Then we come on the right. Intellectual property means that's an idea of any individual. Suppose you are doing any research, you have one idea. That idea belongs only to you. Yes? That is intellectual property is the creation of the human mind. कि आपके पास एक idea है, that is known as intellectual property. And that is intellectual property is of the different types. It's an intangible property that cannot be touched, that cannot be even feel. It's just an idea that is known as intellectual property. नाम देख रहे हो ना? That is इंटेलेक्चुअल प्रॉपर्टी राइट, यानी कि कोई भी चीज आपके माइंड से आ रही है, बाहर आ रही है, आइडिया आ रहा है, दैट इज नोन एज इंटेलेक्चुअल प्रॉपर्टी. अब हम थर्ड वर्ड पे आएंगे, दैट इज नोन एज इंटेलेक्चुअल प्रॉपर्टी राइट. व्हाट इज एक्चुअली द राइट? राइट इज बेसिकली अ बंडल ऑफ द लीगल राइट्स. These are the legal rights which are given by the government of India or given by the government of any other country. Here to the individual who is developing a new product. Suppose you are developing a new pen, or you are developing a new formulation. So the government has given you the rights about that you can only sell that, or you can only manufacture that particular product. Suppose कोई formulation आपने बनाई, तो उसका जो राइट आपके पास है कि उसको आप जो है वो बना सकते हो और उसको आप मार्केट में मैन्युफैक्चर करके सेल कर सकते हो. अगर किसी को वो फॉर्मुलेशन या वो फॉर्मूला यूज करना है, so he or she should give the payment to you. That is the financial value which is provided by the IPR. Yeah? And that is given by the government of India itself. वो government कहती है कि आपको ये rights है कि आप अपनी प्रॉपर्टी को आपकी है, अगर वो आपको किसी को देनी है तो उस third individual को have to give some amount of money, then you can only the any other person can use this. Clear? So that is the, again I am reading, that is the bundle of the legal rights which is provided by the government of India or any other country. Just one thing is there, these are the territorial rights, means these IPRs are only the territorial right, means if you are applying any patent in the India, clear, and you are granting the one patent in India, so that is only itself remaining to the India, not applicable to the US. आप ये सोचो कि मैंने एक पेटेंट कराया, वो इंडिया के लिए है, मैंने इंडिया भी करा लिया, तो पूरे वर्ल्ड में अप्लाई होगा नो, दैट इज ओनली अप्लाई टू द इंडिया ओनली, नॉट टू द अदर कंट्रीज. So that is the, so that's why it's a territorial right. So these are the different types of the IPRs. Two broad categories are there. First is industrial property, another one is the copyright. These different types of the, you can say, IPRs have already been studied by the people from the previous 3 to 4 days में आप लोग यही पढ़ रहे हो ना पीछे. That is patents, trademarks, industrial designs. So first and next slide is the patent. So again patent is comes under the IPR. So that is again a sort of the legal rights. Clear? So but the patent is only granted for the two things. One is the product or it may be the process. यानी कि अगर आपने कोई नया प्रोडक्ट बनाया है तो आपको पेटेंट ग्रांट होगा, या फिर आपने कोई प्रोसेस बनाया है तो आपको पेटेंट ग्रांट होगा. सपोज कोई रिसर्च स्कॉलर है, उसने he or she make one new formulation, तो आपको एक पेटेंट ग्रांट हो सकता है. या फिर आपने कोई ऐसा काम किया है जिसमें कोई नया प्रोसेस इन्वॉल्व है, तो भी आपको सिर्फ पेटेंट ग्रांट होगा, अदरवाइज द पेटेंट विल नॉट बी ग्रांटेड. So that is important here. This is very important. The product, the patent is only granted in case of the new product or the new process. Other things will come under the different another idea. And the validity of the patent means if you have formulated one formulation, so for 20 years it will be yours only. If anybody wants to use that formulation, he or she will give money to you individual up to 20 years. 20 साल तक उसको आपको पैसे देने हैं, तब वो आप उसको कोई और उसको यूज कर सकता है. अदरवाइज दैट प्रॉपर्टी, दैट प्रोडक्ट विल रिमेन ओनली टू यू. Clear? So the validity is for 20 years. Then another is the trademark. Trademark is the distinctive sign. Like this is the sort of the trademark. कोई भी एक अलग से साइन है, किसी कंपनी का साइन है, तो या yes, that is like Coca-Cola, like Intel, computer software के अलग साइन होते हैं, तो that is a trademark. This is industrial design, design of any particular content or any particular solution. Like Coca-Cola की बॉटल का डिजाइन है, माइक्रोस्कोप का डिजाइन है, आपकी टैबलेट पैकेजिंग मशीन का डिजाइन है. So these are the industrial design and which is valid for the 10 years. Then we have geographical indication. Geographical indication means any product which is related to the a particular area, like that of जैसे suppose you are saying Assam की चाय, that is Darjeeling की चाय, Agra का पेठा. So these are the examples of your geographical area, and that is given by the government to a particular state government. Here that is not given to the individual. Geographical design cannot be provided to you, cannot be provided to me. That is only provided by the government to the particular state government. Clear? Then we have copyright. Copyright is the basically an artistic design type of work. If you are making one sort of design or one sort of idea about your research work, that can be copyrighted. Okay, I have planned this and this in my research work. That can be copyrighted, but that should be in the form of the picture, not in the form of the written document. Suppose you are doing one work, our research scholar will be doing some work, they can plan in the form of the pictures. Yes, what I am planning, that can be copyrighted. Then we have trade secret, that is the confidential information about any technique or the product. Suppose there are various like cafe coffee days, like McDonald's burger, so they have some sort of secret ingredient, so that can be kept as trade secret, and that they can be registered under that trade secret. So that is again type of the idea. Now next is to focus here on the patent. So with the patent, three things are important. The one is originality, another one is the non-obviousness, third one is the industrial applicability. These three things are very, very important. The first is originality, means original. Original means novel, naya. That should not be in the public domain. Public domain means that should not be known to others. वो नहीं पता होना चाहिए किसी को, सिर्फ that will be belong to you कि वो original है, वो नया है. उसके बाद third word है second is non-obviousness. That is very important here. Non-obviousness or inventive step. ऐसा नहीं है कि non-obvious means that should not be easily copied. Suppose you are making tea in your houses. So tea cannot, the process of making tea cannot be patented because it can easily be copied. Yeah? But so that means there should be any technical step which cannot be easily copied by the any individual or layman. जिसको कोई भी कॉपी नहीं कर सकता. तो यहाँ पे एक ये सबसे इम्पोर्टेंट है. नोवल तो होगा, नो डाउट. There will be the non-obvious involvement of the technical step should be there while going for the patent filing. Clear? Then next is the industrial application. Yes, that is important again. Industrial application is there because if one wants to formulate something, so it should have the applicability to the society so that it will benefit the society. Otherwise, there is no use for going for a patent. So ये जो patent office है, this will examine these three things in your file, that whether your patent is functional, whether your patent is involved any technical step, and third one is the whether the patent is industrially applicable or practically possible or not. So इसमें in these three, the one thing that is known of business is very important. Again, it should involve any technical step. So these are the three things: novelty, industrial application, non-obviousness is also known as the inventive step or technical step. So technical will take place. As invention should have technical steps that will enhance the science and technology. Now next is the what are the types of patent? These are three types of the basic patent. First is design patent, another is the utility patent, and third one is the plant patent. The first is design patent, means design of anything, exterior look of anything. So that is the design patent. Next is utility patent, means the process of using a machinery. Suppose we have an HPLC or HPDLC in our institute. So the process of working on that particular HPLC can come under the utility patent. Here we cannot patent it, but that can be patented by the manufacturer, or that can be patented by the designer or inventor. जिसने उसको बनाया है वो उसको patent करवा सकता है under utility patent. The next one is the plant patent. If there is any modification in the plant, not naturally occurring, if there is a mutant of the plant, if there is a new variant of the plant after making the hybrid of a particular two plant, that can also be patented under the plant patent. So these are the examples of that is design patent, legal protection for the unique visual quality of a manufactured item. Visual quality के basis पे you will get a design patent. Then utility patent means use of a new machinery. Then plant patent is including mutant species, hybrid species, and new seedlings of any particular plant. और वाइल्ड प्लांट दैट इज नोन एज द प्लांट. ऐसा नहीं है कि आप हिमालय से कोई नया प्लांट ले आओगे तो वो जो है उसका पेटेंट करा लोगे. दैट शुड बी हाइब्रिड वन, और दैट शुड बी म्यूटेंट ऑफ दैट पर्टिकुलर प्लांट. So वो प्लांट जो है can be easily patented. Now that is the basic introduction. Now this is very important. What cannot be patented? ये पता होगा तभी आप जो है you can properly work on the patent idea. That is important. That will cover section 3 and 4 of the Indian Patent Act.
वो चली गई मीटिंग जैसे
Section 3 and section 4. So I want to discuss brief about these sections. That what comes under these sections and what cannot be patented. I have clearly mentioned section 3A, which is saying that anything which is spurious or claiming anything which is obviously contrary to the aesthetic. See, this is the language which is written in our Indian patent law. This is the same language which I have written here. So that means which is spurious means which is not real. Suppose anybody says that there is a machinery which has efficiency of 100%. So anything 100% is not possible. You are doing your practicals, your yield cannot be 100%. Your results cannot be 100%. So 100% accuracy or efficiency cannot be there. So that is if anything claiming कि मेरा जो product है that is 100% pure, so that cannot be possible. So that cannot be tempted, and that is the first point in the section 3. The invention or law which causes prejudice to human, animal or plant which is harmful for the human society, like human clones. Human clones cannot be patented कभी because we जो patent नहीं हुए हैं, because they just only causes of prejudice to human, animal or plant. Another things are also there like gambling devices, apparatus, any invention related to the alteration of the food product, pesticide, they cannot be patented because they cause the harm. Next is the mere discovery of the scientific principle. Suppose one say, I have discovered Newton's law of motion. That cannot be patented because it's already in the, it is become the nature's law. Anybody say, I have discovered E. coli, I have discovered various bacteria. E. coli cannot be patented because it's already in our stomach, in our biological system. So, the mere discovery of any scientific principle which already existing, they cannot be patented. Next is the discovery of the new forms. Like when you say, I have discovered one isomer of the carbon, isomer of the anything, acid of any formulation, that can also not be patented. The next is a mixture of two components, like one is making soap. The soap cannot be patentable. Yeah, if you have two talcum powders, one is silica and the other one is the talcum. If you are mixing and you say, I have made one formulation and which will increase the effect, no, it cannot be patented because you are just involved to mixing. Mixing of the formulation is not permissible because you do not have any technical step. Yes, the powders cannot be mixed and cannot be patented. The next is the rearrangement of the duplication of the devices. Suppose one say I have one fan, another fan mixed with the two, connected with two, and the effect will be more. ज़्यादा हवा आएगी, but cannot be patented because there is no technical step involved. तो कोई भी कर लेगा duplication of the machinery. Then next is the method of agriculture. Agricultural जो methods है उनको भी we cannot patent because they are already in the public domain. Like method of leveling mushroom, method of cultivation of the algae, waste, weed removal method, that cannot be patented. And next is section 3I, that is medical procedures cannot be patented, like tooth extraction procedure, it cannot be patentable. Like administering medicines, that cannot be patentable. Cleaning plaque processes, that cannot be patentable. Diagnostic processes, X-ray, that cannot be patentable. Then mathematical calculation like algorithms, they cannot also be patentable. They can be copyrighted, but they cannot be patentable. Patent नहीं हो सकता. Mathematical calculation, computer software, algorithms, they cannot be patentable. Next is the literary work, dramatical work, musical work, artistic work. This can also not be patented, but they can be copyrighted. It all comes under the copyright act, but they cannot be considered Indian patent act. Next is the a mere rule on mental act, like skit, the performing skit in your festivals or in your different programs. They cannot be patentable. वो patent नहीं हो सकता. Next is the presentation of information, like I am using this visual aid, audio visual aid, that cannot be patentable. That is just a method. Presentation more like presentation by the audio visual method, that cannot be patentable. And even that cannot come under any ICR. Then topography of industrial integrated circuits, like there are some type of sort of chips in the electronic instruments, they cannot be patentable. That any information which have the traditional knowledge, like use of the haldi as antiseptic, use of the turmeric as antiseptic, use of the neem as anti-inflammatory or antiseptic, that even cannot be patented because already in our technical, only in our traditional knowledge. So for that there is a database is also there. There is a traditional knowledge digital library which has all this knowledge, so that cannot be patented. use the turmeric or component of the turmeric in any formulation,